Hello, this is Joel. I wanted to do a brief video series on the probate process in Horry and Georgetown and in South Carolina, specifically Myrtle Beach and the surrounding area. Throughout my years of selling properties, I've helped several clients go through the process, and I do understand there are a lot of emotions, there's a lot of questions, there's a lot of uncertainty as to what to do and how a real estate transaction is going to take place throughout the probate process. So I have a very experienced attorney here in the area. He's done several probate situations for families, effectively set them up on a successful path and given them the knowledge and the expertise to help them get the probate closed and go through that process. So Steve Overson is going to be joining me here in the video series. I hope it's very educational, and again, I as a real estate agent and Steve as an attorney, we can both help you get what you want in the time frame that you need. Hey guys, Joel here with the Advantage Group. As a top producing real estate agent here in the Myrtle Beach and surrounding area, over my years of experience, I have helped several people in the probate situation. However, I am always surprised as to see what clients need to know about probate and how we can educate them to make the best decision. I'm here with Steve Overson. Steve, how are you today?
I'm good, Joel. Thank you for having me here today. Like I say, my name is Steve Overson. I've been practicing real estate and probate law here in the Horry and Georgetown County area since 1989.
It's a few years.
It's a few years. I came to work with this firm as an associate in 1989. And I have slowly moved to where I am the first named partner on the marquee. So all that means is I've been around here a long time.
Gotcha.
Yeah, I mean, a lot of times when I get involved in real estate and probate, it's because somebody that has passed away leaving real estate to their children. A lot of times I will prepare wills for mom and dad who've moved down here from up north. Typically the wills leave everything to each other, the husband and the wife, and then at the death of the second one of the spouses, then the wills typically leave everything to their 3 kids equally. Right. So a lot of times after mom and dad both have passed away, the children will contact me and say, hey, you prepared our parents' wills many years ago. They still own that house in Myrtle Beach. What do I need to do to get it sold?
Right.
Sometimes the children want to keep the house as a second home, but more than likely most of them want to sell it. And so what I do is I will set up an appointment. They'll come in and see me, and they'll bring the original will with them along with a death certificate. And then we will file a petition in the probate court to open up the estate. And typically the will name one of the 3 children in this instance as what we call the personal representative.
The PR,
the
right?
PR of the estate.
Okay.
A lot of states, people are used to hearing the word executor, but in South Carolina, they're known as a personal representative, or PR for short.
Yeah, so let me ask you there, even if an heir is out of state, are they still referred to as a PR?
Yes, because the estate is being administered in the state of South Carolina.
Gotcha.
So what they do is they bring in the will, the death certificate, and then we will file a petition in the probate court to open up the estate and have that named person. They get what's called a certificate of appointment as the personal representative of the estate of mom or dad.
All right.
So that starts the probate process. And your next question may be, well, how long is the probate process?
Yeah, exactly. That's where I was going.
Typically, I tell people that if it's a simple estate, then it's usually a year. Because what happens is once the estate is opened, you have to run a notice to creditors for once a week for 3 weeks in a local newspaper. And the probate court does that for you. And then once the first notice to creditors runs in the newspaper, there's an 8 months creditor's claim period.
8 months.
8 months.
Okay.
So you can't do anything to the estate for that first 8 months. Doesn't mean you can't sell the real estate.
All right.
But you can't really close out the estate until after that time period is over.
So tell me a little bit about that. You mentioned 8-month period that they can't do anything, but they could possibly still sell.
They can't sell. They can't sell the real estate during that 8-month period. But I tell people it's a year because it's 1 year from the date of death bars any kind of claims against that person's estate. So I tell people, there's an 8-month creditor's claim period, but typically it's going to be closed out after a year. But if the will, and there's specific language that gives the personal representative the authority to sell the real property, then they can do it during this 8-month period. So in all reality, if they could list as soon as they get appointed as the personal representative, they could list the property with you, and the listing would be, Tom Jones as personal representative of the estate of mom or dad. And so that's how you would list it with them, and then they can do a contract the same way. And then typically we would close on the property, and the personal representative would then hold those funds in an estate account until the time that the creditor's claim period has expired.
Okay.
Sometimes if there's plenty of money in the estate and there's not really a potential for a creditor's claim, and the creditor's claims are typically hospital bills, ambulance bills, credit cards,
Sure.
If there's a mortgage on the property, they'll file a creditor's claim, but obviously the mortgage would be satisfied at closing, so that wouldn't be a problem.
Right.
So if there's a lot of money in the estate account and the personal representative decides to do what we call an interim distribution, he can distribute some of the money to his brothers and sisters and himself as the PR.
Interim distribution, now was that after probate had cleared?
No, this is during this 8-month creditor's
During
claim.
the 8
Yes,
months.
yeah, you
Okay.
can do an interim distribution.
But you can't, he has to stay in escrow.
No, he can distribute it to them. But what I tell my PRs is I say, if your brother needs some money or your sister needs some money,
Gotcha.
you can give them a little bit of money now, but we need to hold back the bulk of this to get through the creditor's claim period.
Sure.
This is the more prudent thing to do.
Yeah, it makes sense now.
And then really, you're out, the property's sold, and then we just continue with the administration of the estate. I mean, the little things have to be done, like within 90 days after you open up an estate, you have to file what's called an inventory with the probate court, and that is an inventory of all the assets that were owned by the decedent, which is what we call the person who's passed away. But it excludes jointly held property. So if mom and dad had a joint bank account at South Atlantic Bank or CCNB, then that bank account just passes to the survivor at that time. A lot of times after the first spouse has passed away, the surviving spouse will put their children on that bank account as what we call a POD, or pay on death.
Okay.
So then that bank account is what we consider a non-probate asset. So the only assets that are being listed on the inventory are probate assets, and typically that's the house.
That's the house. Of course, they could, maybe it's not real estate, but typically you're going to see some sort of real estate.
You're going to see the real estate.
Yeah. So let me ask you, Steve, I know you mentioned that they can sell it right away, the PR. However, did you say that the will has to be set up to give the PR permission to do that?
Yes, there has to be the language in a will that basically it illustrates the powers of the personal representative. And typically, if the will is done by a South Carolina lawyer, it's going to be there.
Okay.
That the personal representative has the authority to sell both real and personal property. Sometimes we'll get a will that doesn't have that authority.
Yeah, tell me about that.
So if the personal representative does not have the authority in the will to sell the real property, then basically you can file a petition with the probate court asking them to allow the personal representative to sell the property. Or the property, if the will leaves the property to the 3 children, then we can do what's called a deed of distribution from the estate to the heirs under the will. So then the property would be distributed from the estate to these heirs, and then they would be the sellers of the property. But it's a lot easier when the will gives the PR the authority to sell real
Okay,
estate.
gotcha. Well, let me ask you, Steve, then. So if the will gives the PR the authority to sell, you just explain that process, and you also explain the process of if it did not give the PR authority to sell. Is there a difference in the time frame for those two options based on how the will is set up?
If the children decide that that's what they want to do to sell the property, obviously it's a little bit quicker if the will gives the PR the authority
Sure.
to sell the property, because once he gets appointed by the probate court, then he can start that process of listing and selling the property.
Right.
If the will does not give you the PR the power to sell the property, then you have to go through a proceeding with the probate court to, seek a permission or an order from the probate court authorizing the PR to sell. Typically, if the other heirs, the other two children, want to sell the property, it can be done by consent. You just submit a consent order to the probate court, and that'll shorten that time frame. But it's going to take longer if the will does not give the PR the power to sell.
Right. It's going to take longer,
Yeah.
naturally speaking. And those would be the steps. Now, you're mentioning certainly a lot of details, and I'm sure a lot of forms and things like that the heirs would need. How would they gain access to these forms, and where is the role of you? What is your role as an attorney to sort of facilitate those things for your clients?
Well, that's a good question, because a lot of times people will go to the probate court themselves. And in these times since COVID and whatnot, you have to call and make an appointment with the probate court to go over there and see one of the clerks.
Oh, okay.
And then, basically they will help you fill out the necessary forms that need to be filed, like the petition to open up the estate. It's a petition for an informal appointment, and the application for an informal appointment, meaning that there's a will, there's a named PR, so it's an informal process. In today's world, if an individual goes there by themselves, the court will help them fill out the initial petition, and they'll give them a packet of all the other forms that need to be
Okay.
filed along.
Yeah.
So some people actually do this themselves.
But here in our area, we have several out-of-town second homeowners where...
Or it's the
heirs are
children
out
of the
children,
parents
right,
that
yeah.
have, living up in the Northeast,
Correct.
and mom and dad moved down here, and, and we're stuck with that. So that's why a lot of people think it's just easier to hire an attorney to handle the administration of the estate, because everything can be done pretty much over the internet now.
Okay, gotcha.
We fill out the forms, we scan them, email them to them, and they sign them and get them back to us, and then we file them in the probate court.
Yeah.
And a lot of the forms I can sign on behalf of the personal representative, because it's the personal representative that hires the attorney to handle the probate of the estate.
And all these questions that truthfully, many of which are over my head, which is why I always tell my clients, hey, talk to your attorney about this. But I give them general advice. This is really helpful for me as well as I work with these clients. But as far as all these items, these questions, and everything that, heir, for their property would have, this is really where your experience comes into play, and you basically can just take the ball and run with it for them, can't you?
I certainly can.
Yeah. Are there questions like, hey, can we sell now? Do we have to wait? What if we do sell now? How could we fill out this petition? Do you have the form? We're in Ohio. Can you do this for us? I'm sure you see a lot of that.
Oh yeah. And a lot of times, they come down here after their second parent has passed away, and they'll find the will, and again, it's got my name on it and my business card, and they'll contact me.
Okay.
And I tell people, I'm like, look, there's no hurry. Grieve your loss, and then set up
Sure.
a time when you're ready to come in and start the process. But a lot of times they'll come down here. They'll take care of their, service for their parents or whatever they're doing, and then contact me, and I'll say, well, when you get back to town, because there's always the process of going through all of the house and getting it ready to be sold. Then they'll come in and sit down and talk with me and hire me at that point to handle the estate.
Yeah. And as far as the fees, I'm not talking about attorney fees, but fees for the forms, probate, things like that, you would be able to give them all a general idea
Yeah,
of
there's
what they are.
the probate process is not an expensive process. I mean, obviously, you're going to end up paying the attorney more than you're going to pay the probate court. I mean,
Sure.
there's an initial fee to file the petition, and then basically once you file the inventory, the probate court calculates what the fee is for the probate of the asset that's in the probate or assets, and it's not a whole lot. I mean, it's not people hear probate and they cringe
Sure.
and they say, "Oh,
I
I've heard the
yeah.
horrors of probate,"
Absolutely.
but it's not that bad. I mean, for what we're talking about, mom and dads don't have a lot of stuff other than the house that they bought. Everything else that the parents had named their children as beneficiaries on certain accounts, IRAs, 401ks, life insurance. None of that goes through this probate process. It's just
The
the
real
house
estate.
or a car typically,
All right.
a timeshare.
Oh boy, I haven't seen those in a while, but I guess they are still around.
They are still out
I
there.
gotcha.
And a lot of times the kids are asking me, what do I do to get rid of this, maintenance fee on this timeshare? And my only advice is to contact the timeshare company because the will leaves it all to you and your brothers.
Go enjoy a week at the beach, something like that. So as far as you mentioned, probate, it certainly has a cloud of, I guess you might say uncertainty, anxiety, fear for the family, for the heirs, just because I feel that there's so much unknown to it, right? And this sort of video, this sort of educational to the clients, I think is going to help alleviate that concern, that unknown, and get them on the clear path as to what they can do, what they can't do, when they should do it. But let me ask you this. Once probate is, closed, right? Let's say then some of them might sell a property after that. Some of them might not sell. Some of them might sell before, and it'll be held until the creditor's cleared. What is the process then as far as actually closing the estate and dispersing funds?
Well, typically it's like after that 1 year period when all creditors' claims are barred against an estate, then I would work with the PR and we would file the necessary paperwork to begin closing out the estate. A lot of times, if brothers and sisters are close, the other siblings can waive a lot of things like an accounting, schedule a proposal for distribution, a lot of things like that. If they're not, and one thinks that one of them is taking advantage of something, then they can demand accountings and proposals for distribution, basically showing what money has come into the estate and what money has gone out of the estate. But typically, they'll waive that, and then we'll get to a point where we say, okay, we're ready to close out the estate, and we'll get let's just say there's 3 kids and there's $300,000, and each kid's entitled to $100,000. Then we'll get them to sign what's called a receipt and release, basically saying that this is what I'm getting, I acknowledge this is what I'm supposed to get, and then I'm basically releasing the estate and the PR from any further obligations. One thing that is worth mentioning is that in South Carolina, the personal representative is entitled to a fee, and it's 5% of the money that's in the estate. So if a house is sold, that cash goes into an estate account and it's held until it's dispersed. One of the disbursements would be, if the PR decides to take the fee, would be 5% of whatever that amount is. So that's their fee for doing what they're doing. And then obviously the attorney's fees and all the other costs, that comes out of the estate.
Out of the estate.
And then it's, the net is what's divided at the
just
end.
like real estate, any normal real estate closing, you have different fees and things like that. And I always look at it this way. I mean, my wife always, there's things to do around the house or around the yard and things like that. And sometimes I say, hey, I'm going to do this myself. I'm going to save a little bit of money, things like that. But it never works out for me. So I think, in this situation, hiring a good attorney, a good real estate agent to get you on the right path, is certainly going to be money well spent. You've got years of experience doing this. I think a lot of these things can become simple for our clients once it's laid out. I always tell my clients, they always say, let's see, a journey begins with the first step.
Right.
But I always thought of that and I said, yeah, that's a great phrase, but what if the first step is in the wrong direction?
Right.
So when we sit down with clients, I mean, you and I, we're going to come up with a game plan because it is a journey. It could be 3 months, it could be a year, it could be 2 years, could be more, right?
Absolutely.
But we have to make sure our steps are in the right direction. And I'm sure that's one of the commitments you make to your clients. I mean, to make sure things get done. And all these, definitions that you mentioned, and a lot of it was truthfully over my head. We're going to have a list of definitions that you mentioned and some of the other information, on the lower part of this video, and we'll be emailing that out, and we'll have that for our clients as well. We appreciate your time, Steve. We really appreciate your expertise. Is there anything else? I mean, obviously, we know for the heirs, for our clients, that this is a difficult time. This is a real difficult time. You've been there. I've been there. There's a lot of things going on emotionally, financially, throughout the family. So one of our commitments, Steve, I'm sure you would agree, is to part of being an attorney, part of being a real estate agent, is to alleviate that. They shouldn't hire an agent or an attorney unless we have value, right? And in this situation, I found throughout my experience that this is something that we can really show value to our clients, among other attorneys, among other agents, to make sure they're pointing in the right direction. What sort of finishing thoughts?
Well, the only thing that we didn't talk about, Joel, is what if mom and dad don't have a will when they die?
Thank you for mentioning that. Yeah, that was on my last page.
We call that in dying intestate, meaning you're dying without a will. If you're testate, you have a will. If you're intestate, you don't have a will. And so if it's intestate, then you follow the South Carolina laws of intestacy, which, let's say mom is married to dad. Dad didn't have a will, and they owned the property as tenants in common, not joint tenants with right of survivorship. So, and a lot of the old deeds from back in the 90s, that was kind of the norm in South Carolina, was to hold title as tenants in common. That means each mom and dad each owned 50% of the property.
Versus joint tenancy, which
means... they each own 50%, but by being a joint tenancy, when one of them dies, the 50% automatically goes over to the survivor. In a tenancy in common situation, each parent owns 50% of the property. It's what we call an undivided interest. So meaning that when that person dies, the will controls where that 50% would go. And most husband and wives, it goes to each other. But if dad died owning 50% of a piece of property as a tenant in common, and he didn't have a will, well, then it's a different situation, because the laws of intestacy say that dad's one half is then split. 50% of his half goes to his wife and 50% of his half goes to his children. So then in the end, basically mom owns 75% of the property and the two other kids own 25% of the property. So it's a different process. If you don't have a will, you have to file what's called a formal petition in the probate court. And that is, and again, I'll use the example of both mom and dad died, and mom died second, and she didn't have a will and owned this piece of property, and she had 3 children. Well, the laws of intestacy say, since she was the second of the spouses to die, that everything goes to her 3 children. But she didn't have a will, so she didn't have a named PR. She didn't have the authority to sell real estate as the PR. And just several other things. So the 3 kids in this situation would have to decide who's going to be the PR. And sometimes we're lucky and one of the PRs lives in the area and 2 of them live somewhere else, or they all 3 live somewhere else. But typically it's decided who's going to be the PR. And the other ones will sign a waiver of the right to serve as the PR, because they're all three, as children, they all three have the equal right to serve as the PR, but two of them will waive it and request that the court appoint the third one.
Okay.
So then you file the formal petition in the probate court seeking the appointment of the personal representative, and it's granted. I mean, it's just a formality. But then it's a little bit different because you don't have the will that gave the PR the authority to sell the property. So if they do want to sell it, then you have to go petition the court for an order of sale authorizing the sale of the property.
So that's another step, and I'm sure adds on to the length.
Oh, yeah.
of it.
But it's all done during this 8-month period.
During the 8 month.
Yeah,
Okay.
it's all done
So,
during that
okay.
8-month period. So
Gotcha.
it doesn't add a whole, it's just easier if people have wills, you know,
Yes.
it just makes it easier.
Yes, absolutely. So during that 8 month period, if they are going through the formal petition, right,
Or a form, yeah, if they filed a formal petition for the appointment of
for the appointment,
the PR.
clarify this question for me. Can they sell the property while they're going through the formal petition?
Well, that's what I say, they have to get an order.
Get an order
Get an
first.
order from the
Gotcha.
probate court to authorize the sale of the property. And then again, you know, it would be, once you've got that, it's just like the other deal we talked about, the
Sure.
money's going to be held.
All right, Steve. Well, thank you so much. Your expertise, the information you provided has been very helpful, and we hope it's been helpful to our viewers as well. Again, we certainly know that the probate process is a process where there are a lot of questions, a lot of uncertainty, and hopefully we've answered some of those questions and we can alleviate some of your concern. Certainly, we understand, you know, your loss that you're going through. We've all been through that ourselves, and we certainly hope that this journey for you going through this process will begin with the step going in the right direction. All right, Steve. Well, thank you guys so much.
Appreciate it.
It's been a
Joe.
pleasure,
Yep,
and we'll talk to
absolutely.
you soon.
Okay, thank you.